Just gonna give folks a minute or so to get on here, but this morning we are going to be talking about neat little interactive power that we've got as townships, having to do with parking ordinances. So this is a question that I've gotten a couple of times over the course of the last couple of months. And so I figured, might as well create a little resource here for folks in case folks were interested. But before we get too far into it, quick announcement here. So our Township Day at the Capitol is coming up. Now the event is free, although pre-registration is technically closed. We would, if you haven't registered, and I'm assuming most of the folks on here who are interested in this are aware of it, but I feel obligated to plug it again. If you haven't registered yet, give us a call. We'll see if we can work something out. We'd love to see as many folks there as possible. I am pretty excited about this year. We've got a lot of folks coming this time, and we have a couple of particularly good bills that have been introduced in the Senate this year. So we have two separate bills offering $25 million for township roads and an additional 10 for town bridges. Now, for those of you who've heard me talk about this before, the town bridge account has been in deficiency for the last couple of years because of inflation, increase in costs due to inflation. The average project is going up. Right now, there are actually 4 projects that are not getting done because of a lack of funding. So these bills are pretty important, I think, from a township perspective. Quite frankly, as township officers, we all know that our road network is pretty underfunded. So we've got a real chance to potentially move the needle on this one this year. So come on out, please give us some help. We certainly could use the voice of the citizen here, the voice of the township officer. That's the kind of thing that really does tend to persuade legislators to act on this stuff. If you're coming, love to see you. Thank you. If you're not, please consider it. But yeah, moving right on. So parking ordinances. All right. Problem, somebody's parking a junk car on the road. It's an eyesore. There's maybe a safety issue. Residents are complaining about it. Can we do anything about this? The answer is yes. So there are a few pieces of authority that allow us to do this. 169.04, 366.01, and 36510 subdivision 17. And we're going to take each of these pieces in turn and just kind of talk first about the process, second, so specifically why you might want to use the annual meeting as a way to deal with this issue, then the ordinance process, and then we're going to talk at a high level about potential enforcement issues related to if you do attempt to do something like this. Then I'm going to give you some sample documents that are available up on our website and the information library. We actually have 2 separate ordinances that you can potentially use to deal with something like this. So here's the first piece of it. Minnesota statute 365.10 subdivision 17 has a neat little power, and that is this. The electors at the annual meeting have the authority to, quote, grant the town board the authority to provide for a specific activity that is within any of the following categories. And there's a big long list of categories, but relevant to today, I think there are really 3 that we're interested in: protection of public and private property, the benefit of residents, trade and commerce, the promotion of health, safety, order, and convenience. Now, specifically, this power allows the electors to give the town board certain extra authority to be exercised by ordinance. That ordinance piece is potentially important. But the idea here is that township government is a limited form of government. It's something that's supposed to be particularly grassroots and particularly, and for the most part, hands-off. But the idea is that if the electors get together and they all decide that they want a particular activity to be provided for by the government, they have the authority to do that. Now, this is one of our 2 key powers. For those of you who've sort of followed our lectures in the past, our constant metaphor here is from the movie War Games. The guys with the nuclear missiles, they both need to activate their keys in order to activate the power. This is one of those. So the electors turn it on, and then the board has to actually authorize it. Now, in terms of practical language here, this is relatively straightforward. Now, you're going to want to be specific. You're going to want to include the categories that you intend to use to justify this thing. And you're going to want to make sure that this resolution, if you get it, is in writing and it's in a place that you can find it if this ordinance is challenged. Because what we're doing here is we're sort of creating an extra power potentially. Now, one of the interesting things about this legally is that this thing has been very rarely used in Minnesota history, so we don't really know how far it extends, but it does offer some additional protections for a town board. So if you're considering, passing an ordinance, I would suggest it's probably worth your time to get extra authority from the electors, because it just provides that little bit of extra oomph, a little bit of extra legal protection. Now, I've got some sample language at the bottom of your screen there for folks who are potentially interested in using this, where we're, looking back to that language in subdivision 17 in the front there, and we have a clear grant of authority, hereby grants the board authority to regulate parking on our roads. Okay, so assuming that you get this, assuming you're interested, then the next step, the electors by themselves offering this grant does not create the ordinance. All they do is give the board extra authority to provide for this sort of activity. So the next step is drafting and passing that ordinance. Now, most of the formalities for that process are found in Minnesota Statute 365.125 for those of you who are interested in taking a look at it. But if you want the quick and dirty version, this is it. So there's a proper style. Now that one's relatively straightforward. An ordinance must be signed by the chair of the town board and attested to by the clerk. It must have a title, must begin with words like, and that's actually what the statute says. It must begin with words like the Board of Supervisors of the town of blank ordains. So you don't have to exactly use that formality, but you have to be in that neighborhood. Now, this is one of those other litigation averse areas, so we don't really know what happens if you try to play fast and loose with that. But it's probably not worth your time to pass an ordinance to try to find that one out. Just use the traditional style town board of blank ordains, and then as follows. So the next step is that it has to be published. Now, this has to be published in a newspaper at least once. You can, with certain conditions, publish a summary. That summary has to be approved by the town board itself, and you also have to post the thing. So if you have to post an entire copy of the thing, they specify that it has to be at the library, but if you don't have a library, that's okay. Then you can, the board can name another public place to post an entire copy of the thing. The idea is it's not fair to hold people to an ordinance that they didn't have a fair chance to read ahead of time. So, this is one of those due process fair play type deals. And it's also, a matter of statute in 365.125. Now, there is one additional requirement that's a bit of an ambush. If you are, a diligent township officer, if you're reading through the township chapters of law, you would probably not know about this. It's hiding in a different area. You are supposed to record this thing not only in your own ordinance book, you're supposed to also record it at the county law library. And this is a matter of Minnesota Statute 415.021. So the legislature likes to play hide and seek with requirements for us, and this is a very clear example of them doing so. Now, for those of you who are kind of going, oh crap, maybe I haven't done that with some of the ordinances that we do have on the books right now. That is not, so this one actually has been litigated out. That is not going to prevent the enforcement of your ordinances, but it is still a good idea. So if you've got a bunch of ordinances, if you're worried about this, you should make an effort to double check and make sure that they are recorded at the county law library. And partially, this is just another sort of due process fair play kind of thing. If somebody is trying to research local ordinances in good faith, the place that they would probably go or start is at the county law library. So it's supposed to be possible for folks to do that. Now, like I say, there's case law on this. It's not going to defeat the ordinance. It's not going to make it not enforceable if you haven't done this. But still, it's a good idea to potentially check if this is something that you're potentially worried about. Okay. Now, once you have, so if you've gotten your grant of authority, if you've drafted and passed your ordinance, the next set of things to be worried about are practical enforcement issues. So you're going to need somebody to go out on the roads and actually issue these citations. And now that can potentially be your local sheriff's office, but they don't have to do that. That would be a matter of contract. So you're going to have to talk to those folks and see whether or not they are willing to do it. You're also going to need an attorney to appear in court. And once again, the county attorney can do this. I myself worked at a county attorney's office where we did have contracts with a lot of local municipalities where we took care of this stuff. But strictly speaking, that's not part of their statutory duties, so they don't have to if they don't want to. Now, one nice little benefit that we have from this, and one of the reasons that I pointed you to 366.01 is that we have the addition of costs of prosecution onto our ordinances, which means that this should be a more attractive proposition for your local county attorney's office, or even, your local just general practitioner. This is a thing they can potentially recover if they are, if they're interested in doing this. It's a little carrot that you can hang out to potentially, make it more attractive for a local attorney to take this on, or just to keep things cost neutral for the township in general. So we do advise that you throw that language in there. And in the sample ordinances that we cite, that language is in there. Now there are additional sort of statutory requirements that are sort of relevant to this particular exercise. Now, of course, if the issue here is that somebody's parking a junk car on the road, we ultimately want to get this thing off the road, right? Well, there's law on this limiting the ability of municipalities to attack this problem. Specifically, 168B.035 creates some limitations on our authority to tow these things immediately. It also creates a process. So a parking enforcement officer has to create a written towing report describing the motor vehicle and the reasons for towing. Now, in addition to that, you are going to want to document the scene pretty thoroughly because, at some point, if things go badly, you might need to litigate this one out in court. So you're going to need to be able to prove up what you say. If you say this thing was blocking the stop sign, if it was blocking the middle of the road, if you say it was unsafe for travelers, having photos will help a lot. It'll just make it much easier to litigate. Now, it's not your word against the owners. If you've got, a wide angle photo showing the whole scene, another photo showing the specific license plate of the vehicle in question or registration number, other identifying marks, it's a good idea to thoroughly document the scene and to keep it in a report if necessary, if this is a power that you're considering exercising. Now, one thing that you have to be very careful about is that same statute creates certain limitations on our ability to do this. So if we do it and we get it wrong, we have this additional penalty language. So this is owner or driver of a motor vehicle towed in violation is entitled to recover from the towing authority, which in this case would be us, the greater of $100 or 2 times the actual damages sustained as a result of the violation, include but not limited to the cost of recovering the vehicle, including time spent in transportation costs. So this is going to be particularly sensitive for us, given our rural status and how far our towing company might have to go. This could be a not insubstantial amount of money. So you're going to want to make sure that your ordinance reflects the permitted categories very closely, that whoever is ending up actually on the business end of this thing is paying attention to those categories. Now, of course, those categories are mostly pretty practical. There's a big list of them in that statute. And frankly, for the reasons that we would be concerned about doing this, it's pretty clearly permitted, I would say, at least in my opinion here. Because we have a couple, there's a clear one. If you are getting in the way of the snowplow, then you can be towed immediately. If you are abandoned, so the standard for abandoned is that it's been parked illegally for more than 48 hours. then you are good to go. So these things are in the ordinances that I'm talking about. So if you're paying attention to that language, it should be just fine. But this is something that you should be paying attention to if you are considering exercising this power. It's the kind of thing you don't want to screw up. So as I say, we've got some example ordinances here in our information library under Township Roads. It's document TR 20,000. That's the sample parking ordinance. And then there's an alternative way of handling this, which is in our basic road administration ordinance. So this is under the information library. If you go to Town Powers, document 8,000, that's the basic road administration ordinance. And that one treats that one is more of a generalized obstruction kind of junk kind of way of thinking about this, rather than more broadly the parking interfering with plow, interfering with visibility of stop signs or other traffic, that kind of stuff. Both legal. We've drafted both of those pretty carefully, so you kind of get to take your pick there. All right, let me go ahead and share my screen here. Go. All right. So thanks very much, folks, for your time and your attention. Does anybody have any questions? Anybody interested in follow-up? Okie doke. Well, hearing nothing. Thank you very much for your time and your attention. For parking on the street during and overnight. So the sample ordinance is, let me call it up here. Yes. So if you are hitting that abandoned standard, if somebody's just leaving their car on the road permanently, if you're hitting that 48 hours, then yeah, you can use it. Some of the other examples of stuff that is useful for. So if you're blocking the plow, if you're parked in violation of snow emergency regulations, if you're blocking a driveway, if you're blocking an alley, if you're visually blocking a stop sign, if you're partially obstructing the traveled portion of the road, or if it's junk abandoned or otherwise unauthorized, then if you pass this thing, then you're permitted to tow it. So just a potential tool in the toolkit to help you administer your streets and your roads. Yes, it does.
Thank you, Graham. We appreciate you doing this presentation for us.
Okay. Well, Gussie, did I see you on mute there?
Hey, I have a question too, Graham. We have a conditional, or I think right at this point it's an interim use permit, but in that interim use permit, we have told them that they can't have any parking on any of the township roads during that time. They'd have to park within the event. What is our, how do we regulate that if they're on the road? Can we call a tow truck since it's in the conditional use permit for this event or the interim use permit?
I would be a little careful about that. Now there is in let's see, excuse me, it was 365B.035. One of the ways we can tow somebody immediately is if we post up temporary restricted parking. So in this case, you're doing an event. So if you want to do that, it has to be at least 24 hours in advance, because we're not, the big cities get 12 hours. We have to do 24. But if you post that thing up, then you are covered as far as the double damages provision in 168B.035. Now, there is an argument that there's kind of that by contract you get access to this power anyway. But I'm a belt and suspenders kind of guy. I think that you probably want to do both before you start towing. So because you don't want to create a situation where somebody even thinks they might have a cause of action, right? Because if they drag you into court, you potentially are on the hook for for legal costs, even if you win. So I would recommend pretty strongly
So
that
that
you do.
signage would be within the right of way then? Is that-
Now, in the right of way, there's also, and that one gets a little bit more complicated because there's 169.0125, I believe it is, which says you can't obstruct rights of way. So you could say that that's a misdemeanor as with respect to state statute, and so you can get rid of it. So there's kind of that extra layer there, but still, belt and suspenders. I think you should, if you want
How
somebody, I
about
think
signage? Can we put signage in the right of way? That
uh, not obstructing the traveling portion, obviously, but yeah, you do have the right as a road right to say, no, we're restricting parking in this particular place at this particular time. And that'd be 169.04. That's the authority for that.
Thanks, Graham.
Okay. Well, folks, I hope this was a helpful little resource. So thank you very much for your time and your attention. I look forward to seeing each and every one of you at Township Day at the Capitol. And have a nice morning.